Hello everyone, welcome to my YouTube channel. Today I'm going to be talking about will the Trump presidency or the Biden presidency change the outlook of the EB1, EB2, NIW employment-based visa. I know we've been having questions, but in today's video, I'm going to be talking about the overview of the EB2, EB1 visas and what they are and how it came about. I'm going to also be talking about the bill or the act that made it possible, how it was enacted into law, and what the US Constitution talks about it. I'm also going to be talking about Trump's immigration presidency, immigration policies, that is in the past, what he is like and what he stands for. In addition to that, I'm also going to be giving my opinion about the the future of the EB1, EB2 visa. So if you are here and you want to know more, I will want to ask you to stay to the end of the video as I'm going to be analyzing this issue in this video. Feel free to go ahead, like my video, subscribe to my YouTube channel as I will be giving you exciting content on employment-based visa, the EB1 and the EB2 visas. And I'll tell you, I have an exciting video coming later this week where I'm going to be talking about the membership of professional organization as it regards the EB1A visas. Please stay tuned. Let me start with the EB2 NIW visa, which is actually an employment-based visa reserved for people with exceptional ability, either in the arts or sciences, business, or whatever field you are. And the US, they are actually looking for you to demonstrate that your proposed employment, your proposed endeavor is of national interest and is going to benefit the United States when they grant you the employment-based visa, that is the EB2 NIW. And also, they are also looking at that it's going to be sufficient to waive the labor certification, in the interest of the nation. That is to say that whatever you are proposing to do is going to benefit the United States. So they need to waive the labor certification on your behalf. So now, having discussed that, why is it different from the EB1? The EB1 is actually the higher category that actually requires that you meet 3 out of the 10 criteria listed on the USCIS website. I'm also linking the USCIS website where I want you to go ahead, look at the criteria and see if you qualify for the EB1A visas. But the most important thing is that the EB1 is actually, I would just call it, for lack of term, the elder brother of the EB2, but because the EB1 requires you to show more evidence that you have sustained a national acclaim, that you have performed at the top of your peers, and you have certain things that are not actually, they are actually extraordinary, because you have to demonstrate that you have extraordinary abilities actually in the arts or in the STEM field or whatever field you are. And the extraordinary ability that you demonstrate in the EB1 is quite intense and different, not actually different in the sense of being different, but actually you have to go into more depth to demonstrate that you have achieved this because of you have extraordinary ability. Now let's get that out of the way. Let's talk about how the EB1 and the EB2 employment-based visa, how they came about. And I've actually did a lot of research, and I'm going to be reading from the script that I have in front of me. And the employment-based visa are part of the Immigration and Nationality Act, the INA, which was enacted in 1965. Now, I want to stop here and tell you that I have taught immigration courses at the universities, at about 3 different universities in the United States. So I understand immigration from a research-based perspective, and I've taught it in my classes. So I will say that you should take this from me as someone who has done their research. And the INA established the legal framework for immigration to the United States, replacing the earlier laws and providing foundation for modern U.S. immigration policy. But the INA, which is the INA 1965, which is the Immigration and Nationality Act of 1965, the act abolished the national origins formula, which has been the basis for U.S. immigration policy since the 1920s, and he placed it with the preference system that focused on immigrant skills and family relationships with the U.S. citizens and residents. So what am I saying? That the INA Act of 1965 was more focused on the immigrant skills and their relationship with families. So they are looking for specific kinds of people and what they could bring to the United States. So fast forward to 1990, and I'm going to be talking about the Immigration Act of 1990. And it is this law that actually gave birth to the EB2 and the EB1. So this act significantly amended the INA, increasing the total level of immigration and, most importantly, for employment-based visa, creating 5 distinct employment-based visa categories: the EB1, the EB2, the EB3, and the EB3s were introduced, and also the EB4 and the EB5. And they were mainly introduced to attract highly skilled workers, professionals, and other workers who could contribute to the United States. So let's look at it. That this was an act passed by Congress. The U.S. Congress means that it went through the House of Reps, it went through the Senate, and it was approved and passed into law, and the president signed up for it. So it is not an executive order. Now, I'm making it clear that the EB1 and the EB2, the laws that gave birth to these laws, the employment-based visa category, is not an executive order. So it means that any president cannot come up and cancel the executive order enacted by the previous presidency because of reasons best known to them. So that being clear, so let's talk about, can employment-based visa be repealed by any US president? So I have said it earlier that it is not an executive order, it is a bill passed by Congress, and it was signed into law by the US president at that time in 1990. So the answer to my question, that can any U.S. president repeal the Immigration Act of 1990? No, it cannot be done. A U.S. president alone cannot repeal an employment-based visa such as the EB1 and the EB2. And here is why. I actually did my research, and I'm actually giving you a research output of my findings and why I'm giving you my opinion here. Because number one, it is backed by the legislative power, and the authority to create or repeal the visa category lies on the U.S. Congress, which enacts legislation. Any changes to the INA or specific visa categories must be made through legislative process, which includes passing a bill in both the House of Representatives and the Senate, followed by the president's signature. That is to say that if you want to start repealing any part of the Immigration Act of 1990, it has to go through the U.S. House of Reps, it has to go through the Congress, and before it has to be signed by the president. And if you have actually lived in the United States so long and you've been following what the Congress and the Democrats, the Republicans are doing, I describe them in my own term as cat and dogs that do not agree on any single thing that happens within a house, which means that sometimes the Democrats might agree on something and the Republicans will say, no, we want certain things to be adjusted and you are not helping us to achieve it. Therefore, we are not going to sign off on this bill. So these are how the Democrats and the Republicans have been acting. And if you've been following the laws that have been enacted, you will notice that sometimes they agree on 99%, and that 1% will cause a law not to be enacted. So based on this, it makes it hard for any US president to repeal any part of the Immigration Act of 1990. So let's look at it from the executive point of view, that is the executive orders. While a president can influence immigration policies through executive orders and administrative actions such as setting visa priorities, changing enforcement practices, or issuing new regulation, these cannot directly repeal or fundamentally alter employment-based visa categories by law. Executive orders can, however, affect the processing, allocation, administration of these laws. That is to say that a president can come up with an executive order that says to limit the amount of employment-based visa category that is available. It can also alter, how many employment-based visa category that is available. And if you're actually doing or following the employment-based visa, especially the EB2 or the EB1, you will understand there is a visa bulletin, and the visa bulletin makes us understand how many visas that are available in a particular month or year, as it might be. So it means that a Trump presidency, for example, or a Harris presidency can actually come up to limit the amount of visa that is available. And I think that it might not actually go that route, because the Immigration Act of 1990 was enacted to provide the United States with a highly skilled workers. And if at all they do anything to to alter or change the course or the pathway of this EB1 or the EB2, the United States is likely going to be suffering from the number of skilled workers that they require to to function effectively. I will give an example. One good example I have in mind is the critical and emerging technology that listed things like cyber security, advanced computing, biotechnology, and what have you. These are part of the critical and emerging technologies, and most STEM fields are listed under this critical and emerging technology. And you will notice that you hardly find a non-STEM field there. So the US is a country that relies on the influx or the growth of STEM field for them to survive. It means that if the STEM field dies in the United States, the country is likely going to crumble. Now, what am I saying? What am I saying? That the influx of international students, despite those in the STEM field, they need more STEM field. They need more people in the STEM career to join, to become green card holders and become citizens, because the country relies on the STEM field to survive. Now, it means that if the president or any president do anything or does anything that alter the pathway of the employment-based visa, it means that the United States is going to pay dearly for it. So I don't think any president will want to go in that course of action. Now let's look at regulatory changes. I've talked about two things. I've talked about the legislative power. I've talked about the executive orders, and I want to talk about the regulatory changes. And these regulatory changes, I'm talking about the executive branch through agencies like the USCIS and the Department of Homeland Services can issue regulations that impact how visa categories are managed. These regulatory changes must go through formal rule-making processing, which includes public notice and comment periods. What am I saying? In other words, I'm saying that the US can the US a US president can actually go through the USCIS, the Department of Homeland Security, in order to make these changes. And I don't see that happening, because like I just explained earlier, that if they go through that route, it might actually impact the number of high-skilled workers that they're attracting in the United States. And the reason why I think that they're not going to do that, because their neighbor up north, Canada, is interested in attracting these high-skilled workers. Why Canada may not be the best destination for people that have landed in the United States, built their lives here, got the training. However, Canada may be the next option for people, because Canada is an attractive destination, but not as attractive as the United States. I don't mean any insult to my friends in Canada. Now, judicial reviews. Actions by the executive branch are subject to judicial reviews. Courts can strike down executive orders or regulation that exceeds the president's authority or violate statutory or constitutional provisions. It means that even if the president come up with a law to limit the number of employment-based visas through executive orders or something that they think is of the nation's interest, that the judiciary can come up to challenge it in court. And if you are aware of Trump's presidency, when he won the election during his first term, he came up with an executive order that banned certain people from coming to the United States. and it was challenged in court, and he lost that court case. And if you know the United States very well, the lawyers know their job and they know how to challenge any president at all, and they sometimes they win, the presidents lose. And I don't think that the any incoming president will want to go through that route to challenge the Immigration Act of 1990. So now we have gotten that out of the way. Now, what do I think is going to happen for any incoming president? Will they want to challenge, or will they want to repeal the Immigration Act of 1990? I don't see that happen. That is to say that no president can actually repeal that law, because it passed through the House of Reps, it went through the Congress, and it was signed by the then president that was in seat at that time. It's going to be a hard job for any president to go through that route just for the sake of repealing the Immigration Act of 1990. And if they actually go through the executive orders, want to challenge or limit the number of visa categories, which is fine, which is something that we have been enduring for the past 1 year when there was a retrogression. But I don't think that any president will want to go through that route to do anything that will harm U.S. chances of getting high-skilled workers in the United States. Now, what do I think about Trump's presidency in a whole? Now, like I mentioned, I'm not here to discuss the next president who is going to win, but I'm just actually trying to analyze their immigration stand and what they stand for. And if you ask me, I will tell you what I think. Let's start with Kamala Harris. Kamala Harris is a Democrat, and the Democrats, they have this thing for immigrants. So what do I think? That she is going to likely maintain the open border policies, but with a slight change like what they have done during when in the past few weeks. And I think that they might still want to keep the thing for immigrants. They will keep it open if Democrats win. Now, what do I think of Trump's presidency? Trump presidency will follow the likelihood. It will follow the steps of his first presidency, and he has made it clear that he wants immigrants from certain parts of the world. And remember when he said that he wants immigrants from Norway. He doesn't want people from some whole countries, and he specifically mentioned Africa as a continent. So I don't think that I don't think he has changed in terms of the things he does, and I think that he's still someone that doesn't like immigration policies as a whole, because he has said many times he doesn't like people coming from the southern border, and he called them criminals and he called them rapists. So that is what he thinks about open borders. And he also said that during his first run as a president, he limited the number of asylum seekers in the United States. That these are, I mean, the asylum seekers that they have the legal obligation to come from either Turkey or North Africa. I mean, the Ethiopians, the Eritreans, the Somalia. So he limited their numbers. So I think he's going to continue that route. Do I think he's going to go for the Immigration Act of 1990? I don't think so. I think that the employment-based visa is going to continue. Now, what do I think? What do I think that about the incoming president and the impact of so so let me answer the question now. Do I think the next president, either Trump presidency or Kamala Harris presidency, is it going to affect the employment-based visa? I don't think so. I think that we should go on our daily lives, try looking for ways to get every document that we need to get our employment-based visa, either the EB2 or the EB1 approved. Let me conclude this video by saying that, number one, I said in this video that the employment-based visa, it started in 1965, the Immigration and Nationality Act of 1965, the INA. It was what gave birth to what we would describe as modern day immigration. Then in 1990, there was the Immigration Act of 1990, which actually, enacted the five employment-based visa category. But I'm actually in this video, I'm focused on the EB2 and the EB1 visas. And what do I think? And I also explained that the Immigration Act of 1990 it came out as an act of Congress. It went through the House of Reps and the Congress, and it was signed by the president. So it's not something that could be repeated easily because um because the any bill that went through these houses cannot be repealed. However, it can be amended, it can be adjusted, because if you notice that I said that the Immigration and Nationality Act was actually amended to give rise to the Immigration Act of 1990. And one thing I said that I want us to take away from this video is that the Republicans and the Democrats are not friends. They always fight. So any law that is going to come up to replace the Immigration Act of 1990 is likely not going to go through Congress. It's likely not going to pass through House of Reps. Therefore, I do not think any president is going to come up to repeal this the EB1, and I don't think that any presidency is going to I use the word negatively affect the employment-based visas. That is the end of my video. If you have not subscribed to my channel, please go ahead, and I think that this video, go ahead, like my video, subscribe to my YouTube channel, share it with your friends, as I will be making more exciting video that sharing my opinions about the EB2 and the EB1 visas. Thank you for watching my video. I will see you in my next one.